Check, check, check.
Are we on?
Is this on?
Good evening, everyone, and
Check
welcome
one.
to tonight's meeting of the Holmdel Township Zoning Board of Adjustment, today being October 19th. Call to order, please.
In accordance with the Open Public Meetings Act, NJSA 10410, and the regulations governing remote meetings, NJAC 539 1.5, I hereby announce that adequate notice and electronic notice of this meeting was provided in a notice dated January 19, 2022, that was sent to the Asbury Park Press, 2 River Times, posted on the bulletin board and on the main access door to Town Hall, filed in the clerk's office, and posted on the township's website, www.holmdeltownship.com.
Roll call, please.
Ms. Abbott? Here. Dr. Blumenthal?
Here.
Mr. Berko?
Here.
Ms. Campus? Here. Dr. Lateef?
Here.
Mr. Luciani?
Here.
Ms. Rofanatopoulos? Ms. Perez?
Here.
Dr. Shaw?
Seat Ms. Perez for the absent Mr. Anatopoulos for all items on tonight's agenda. Please stand for the Pledge of Allegiance and then remain standing for a moment of silence to honor the police, military, and wounded or killed in action. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Item number 1, a continued public hearing.
470 Red Hill Road, Dementia Center preliminary, final site plan number 2020-6, block 4902, lots 40, 40Q, and 41 in the R40B zone. Applicant seeks a use variance to create an assisted living residence, which will be a facility for those suffering from dementia for 105 residents. The facility will consist of a state-of-the-art residential memory support program that will house a variety of innovative programs and building design concepts, including an assessment program, educational services, and extensive community outreach and support.
This is a continued public hearing on this application after a number of prior public hearings. Tonight is going to get some summaries from the various parties, starting with Mr. Brown. Do you have anything new for tonight?
I have no new evidence or anything. I'm ready to present my summation. My understanding was that
Correct. The one other thing I will simply announce here, so not everybody is aware of it, 2 weeks ago, Bill Potter died. So there's recognized that he was a long-standing member of the community, and he's not the applicant here now, but it was in part we've certainly thought about him as we've gone through this process, and he did provide some testimony at one point. Mr. Clancy, you represent Middletown Township.
I do. It's on, right? Good evening. Yes, just if I can, I'll report some of our, just a brief summary of our points on this. Township of Middletown objects to this application for the use variance at 470 Red Hill Road. The applicant submits to the board an application to situate an inpatient dementia care center in an R40B residential zone. It's the current site of a farm, permitted use under the zoning ordinances of Holmdel Township, as you all know. The applicant asks the board to grant an exception, which undermines the decades of careful planning through the Holmdel Master Plan and its periodic re-examinations, along with the zoning ordinances. The Holmdel Township planners and elected officials wisely anticipated the need for facilities just as these, and specifically designated wide swaths of the township for these purposes. You heard sworn testimony from expert witnesses who provided examples of specific sites available for this very project that would not require a use variance, because they're located in a position that the township expressly dedicated for this purpose. The applicant has not met their burden for establishing that the board may grant a use variance for the dementia center, despite the fact that the proposed facility meets the definition of inherently beneficial use under the municipal land use law. That's not a green light to approve the use, or to approve a use variance. The Supreme Court has outlined in the Sika case that zoning boards must still evaluate the negative aspects that the grant of a use variance would create. The court mandates the zoning board to evaluate 4 pieces of information to determine if a use variance is permissible in this particular instance. It requires they evaluate the public interest served by the inherently beneficial use, they identify any adverse consequences for the granting of the use variance, consider any conditions which might be imposed to mitigate any adverse consequences, and then balance the public interest of granting the variance against the adverse impact to determine if there would be a substantial detriment to the public good if the use variance were granted. In evaluating the public interest served, we find an incredibly narrow swath of the population that would derive any benefit from the facility. Dementia affects less than 2% of the population, most of whom are over the age of 65. The majority of that group suffer from additional medical conditions that would likely preclude them from residing in this proposed facility. While the applicant has identified a population certainly in need of services, the board is charged not merely with recognizing that a public benefit exists, but more importantly with evaluating the degree and extent of the public benefit derived from that proposed use. The board cannot grant a use variance for such a niche use facility. A number of adverse consequences have been identified should this use variance be granted. Holmdel and surrounding communities will lose another farm, a feature which distinguishes the character of this community. An entire highly sensitive R40B zone will be lost. The extensive research and careful planning used to develop the Holmdel Master Plan and the zoning ordinances would be ignored, despite the fact that each dutifully and specifically considered the need for such facilities and outlined suitable locations for their placement elsewhere in Holmdel. Landscape features would be drastically changed to accommodate the project, with the potential to negatively affect the downstream Wackack and Morass watershed in Holmdel and neighboring Middletown. The proposed impervious surfaces exceed which is permitted in this zone by nearly 7%. The proposed facility would result in a disproportional drain on emergency services for Holmdel and surrounding communities, given the nature of the proposed facility, the age and condition of the anticipated residents, and the facility's inability to provide emergency medical care. The board has not imposed any conditions to effectively mitigate these adverse consequences, largely because they simply cannot be mitigated. There exists no condition that can mitigate the loss of an iconic farm. This board cannot impose a condition that will create another 18.5 acres of R40B zoning. Despite the analysis of data points, no imposed condition will mitigate the potential future downstream effects of the proposed large-scale land resculpture and increase of impervious surfaces that would be caused by this application. And the board must balance and weigh all this against the public interest of placing a dementia facility on farmland, something the master plan specifically directs that you preserve. Clearly, the grant of a use variance would constitute a substantial detriment to the public good. It is our feeling that the applicant has not met their burden underneath Sika, and the zoning board should deny this application. Thank you for your time.
Thank you.
Thank you.
Thank you.
Mr. Asadi?
Thank you for giving me a few minutes of your attention this evening. You've heard many months worth of testimony from the applicant's team, from my client's witnesses, in addition to many members of the community. You have a lot to consider, and I know you continue to consider this matter with extreme care and deep devotion for your legal duty and what's best for Holmdel. We kept hearing about Amsterdam, and that this concept has not once been attempted in the United States of America. We heard how wonderful the Hodgewick facility is in Amsterdam. You heard testimony from our planner that the Hodgewick is located in a district that is dense, industrial, located near high-density housing projects on a smaller site than this one. You heard that Holmdel Township has a whole zoning district set aside for this kind of use. This project belongs in the Route 35 overlay district, not in a rural R40B zone. Throughout most of the duration of these hearings, it was positioned by the applicant's team that approval was inevitable, compulsory. In other words, the flavor that you had for months was that the board lacked the discretion to deny the application, even if it wanted to. and I believe that some of you want to deny this application. I've heard some of you say that the design reminds you of army barracks or garden apartments, that the buildings are ugly. 105 units. Why so many? The applicant said that this density was needed to serve its own financial interest. Remember, we're talking about an R40B zone, the purpose of which, in part, is to zone existing low-density areas in a manner consistent with existing development in the R40A district. In the R40B district, the lower density will reduce the overall impact of development consistent with the undeveloped rural character of these areas. Does this use in the proposed intense commercial site plan advance this purpose? Of course not. This application is antithetical to the R40B zone purposes, and this proposed site plan spans the entire zone district. The applicant will argue that a nursing home, or specifically in this case a dementia care facility, is an inherently beneficial use, and under the land use law this entitles them to an approval. They might be correct that dementia care is an inherently beneficial use. We don't believe they've necessarily proven that here, but what about the other uses that they're suggesting? Particularly this outpatient evaluation clinic and education center that the applicant proposes. That's just one example of an additional principal use. An additional principal use that is not permitted in the zone, one that is not inherently beneficial, one that requires special reasons to be permitted and approved by this board. No special reasons were given. Therefore, you don't have to approve this. But let's imagine for a moment that all of the other additional non-permitted principal uses were excised from this application and we were left only with a dementia care facility. And let's suppose for now that the applicant was successful in demonstrating they've met the standards for treatment as an inherently beneficial use. But that's not all the applicant needs to show. The applicant needs to demonstrate that it has satisfied the so-called negative criteria. I want to focus on one specific prong of the negative criteria. That is the notion that approving this application would not substantially impair the intent of the zone plan and zoning ordinance. It doesn't only impair the intent of the zone plan, approving this application would obliterate the zone plan. Why do I say that? You saw the zoning map. This R40B zoning district is constituted entirely of this particular subject property. Granting these requested variances would necessarily rezone this entire particular zoning district. You don't have the right to do that because that is a legislative act. Only the governing body can rezone this R40B zoning district. But back to the question of the negative criteria. Would granting this variance substantially impair the zone plan? You bet it would. We put planning testimony on the record as to this point. It was not refuted by the applicant's planner. You have every right to deny this application. I'll take it one step further. We've not only proven that the board can legally deny this application, we've proven that the board must deny this application, as what you're being asked to do exceeds your powers under the land use law. That's right. In the weeks following our experts' testimony concerning this, my clients and other members of the community started to hear rumors that there's concern, maybe even threats, of a federal lawsuit under the Fair Housing Act if this application...
Objection, that's not in the record, it's beyond the scope of that entire hearing.
That's right. Objections noted. We're going to let him finish his summary.
maybe even threats of a federal lawsuit if the Fair Housing Act, under the Fair Housing Act, if this application were not approved. You may have heard these rumors yourselves. You may have even been contacted by certain people improperly directing you to approve this. This isn't the time to investigate that, but I want you to ask yourselves, are you going to kowtow to fear and approve an intense commercial site in the rural R40B zone? And do you believe that Holmdel has failed to provide reasonable accommodations for this kind of housing? Your own EMT came in and practically begged you not to approve this because existing developments of this kind are already overwhelming their capacity to provide service to all the people of Holmdel. To me, that suggests that there's no lack of plentiful accommodations already. In many ways, this vote tonight is your legacy as a member of this board. If approved, from this day on, people as they come off of exit 114 to visit Holmdel and they see barracks and an intense commercial site surrounding it, they'll wonder, what happened here? Will you be proud of this project? When advances in medicine develop treatments for dementia in the form of a pill or other treatments, such that a facility like this won't ever be necessary, and God willing, that happens soon. Or if this is a one-of-a-kind pilot concept that fails, how will these barracks in your rural zone be maintained? When that happens, will people wonder themselves, what was the board thinking when they approved this application? Do you want your name to be associated with that? You're considering approving an intense commercial use on a site that is least able environmentally and from a zone plan perspective to accommodate. Tonight, you are the stewards of the front porch of Holmdel. Your action on this will be remembered by every single person who passes by there, who visits the town thinking about purchasing a home, who comes home to visit their parents and are used to seeing a low-density, rural vista at that location. They will see nothing resembling an R40B zone forever. I don't believe that you want army barracks which are tied together by an impenetrable wall like a fortress here in this location. I don't think you want the dense 105 units and the large commercial parking lot and all the emergency calls to this particular rural location. I think perhaps you felt a compulsion to approve something you would never ask for in the R40B zone. So I hope you heard our experts. There's no compulsion to approve this. Frankly, as I've said, we believe the board lacks legal authority to approve it under the land use law. Use the information that we gave you and follow your hearts to do what's right as zoning board members and as people who very obviously care deeply for the Township of Holmdel and its future. Thank you for hearing me, and good luck with your vote.
Thank you. Thank you. Mr. Brown?
Thank you, board members, for all your time, effort, and patience over the last year as you considered this application. I'd like to follow Dr. Blumenthal's comment by starting by indicating formally how UMC extends its condolences to the entire Potter family on the recent and unexpected loss of our
Pull it closer.
Yeah. You want me to start afresh?
If you would, then why don't you pick up on the recording?
And start again?
Yes, please. Yeah, please.
Okay. I have it in writing so I can say it again. Again, I thank the board members for all your patience and your kindness over the last year in considering what we presented before you. And as I started to say, following up in Dr. Blumenthal's comments, we do extend condolences to the Potter family for the unexpected recent loss of Bill Potter, who was a great gentleman. And as the obituary said, he smiled as he provided wisdom to those around him. And I think that's very true. But now as to the application. On July 8th, we presented to you a 6-page summary as was requested, along with a 30-page addendum or appendix, which included references to all the transcript sites, exhibits, and the like. I'm not going to focus tonight on all that, and rather I'm going to concentrate on the comments you heard tonight from the council for the objectors. And to expedite this, I've prepared this PowerPoint, which you have copies of right now. Now, don't be concerned about the number of pages because I'm quickly going to go through this. I was trying to anticipate what council would say, so there will be some portions where I'll just glance by it. and you can for the record, we're trying to move the monitor around so members of the public can see better. And has that been accomplished? I'll wait a minute.
If we can get both screens working, that will help.
Yeah.
Oh, so a little more for the board. Yeah, I think so.
Yeah.
Yeah. Can the public see the other one a little bit?
Yes.
I mean, that land board secretary.
Wall Street.
So I think I did anticipate properly what Mr. Clancy and Mr. Asadi were going to bring up. And so you'll see I have 7 points to address what they actually have talked about, and I'm going to go through those briefly. Now, for each one of these, what I've done is that I indicated who the objectors were, what the specific assertion or objection was, and I followed that by responses relying on citations and transcript notations and the references to expert testimony. But I'm just going to summarize these slides. So, I mean, if you have any questions at the end, you can either ask me or ask your board professionals to clarify it. So first, as to the allegation that the board can't consider the economic status of potential residents, that is not backed up by the law. But what you should consider is that one of the benefits of accepting the project is that the township will automatically receive substantial COA credits, and that 10% of the population at the enclave will be Medicaid eligible. Next, this is slide 3 for you. It was mentioned about the farm and how it's going away and how people love it. Well, that is legally irrelevant for consideration. You can't consider whether or not the present hobby farm can remain. And as Kate indicated to you at the July hearing, you can't consider Middletown's claim as to loss of the farm because, quote, the property is loaned for other uses. And from a zoning point of view, a farm is just one of the things that is permitted here. Also, as you heard at great length, Jim Higgins indicated that there are far more intensive potential uses permitted under the zone which could be built there if this application is not approved. Likewise, you heard testimony that if the application is not granted, that 3-acre commercial parcel that's at the entrance there, that will continue as a matter of legal right. Next, S4. You heard the mention of EMT, EMS. You heard the representative here. You cannot consider what that testimony was. The law is clear that to the extent that the enclave may use emergency services and the costs associated with it, it cannot legally be considered by the board as having an adverse impact or as being an undue accommodation because such a consideration is legally discriminatory and it's backed up by substantial case law. S5. As a matter of paramount public policy, the board cannot consider the fact that UMC or subsidiary are nonprofit organizations for the purposes of considering impacts due to the payment of taxes or the payment in lieu of taxes. Now, Mr. Asadi referred from his own point of view to what's S6. He kept on telling you don't have the legal right to consider this. It's not, absolutely not true. And your own professionals have pointed that out. At the July hearing, Kate and Marty clarified that the board cannot consider that case relied upon by Mr. Gemma, which is called the Dover case. The property is only one small portion of the greater R40B zone in the township. So that case that was relied upon has no relevance to the facts of this case. When you heard comments that it would take up the whole district, absolutely not true. The board has full rights and should consider the grant of the use variance which is sought. S7. Mr. Gemma made a claim that we hadn't shown where the area is, and that wasn't brought up tonight, but we certainly did. We brought that up extensively way back in the fall, and I'll leave it that way. If you have any questions about what the area is or where it is, you can ask me or ask your professionals. Going over to S8. Now, Mr. Gemma, who is one of the two experts that Mr. Sadi points out testified for his group, he makes no objections that there's a physical negative impact on the neighbors. His sole claim is that there's harm to zoning. He claims, as Mr. Sadi indicated, that dementia centers can only be in the Route 35 zone. And on slide 9, there's a list of what his claims are.
So just slow down a little bit. Just look at the screen because some pages.
Yeah, we're missing a couple of pages here. It's,
In our,
I'll just keep it up, the screen up there, that's fine.
Yeah.
Yeah, I can read up there.
yeah, we're
Okay.
missing.
Just let me know when you want us to.
We're missing pages 7 through 12.
Yeah, exactly. Same here.
No, it's
As long as the
okay.
screen's up
We
there,
can
it's fine.
see
Yeah, the
yeah,
screen's
we're
fine.
I take blame for that. I put them together myself this morning. Must have been a little tired. We have extra copies.
No, that's fine, it's fine. I
All
can
right.
read right here. This is great.
Just raise your hand if you're ready for me to move on. These are just the details of his claim, and you heard him say that. I was just giving him the benefit of the doubt of clarifying what his claim was. Now on slide 10,
Just go ahead.
Mr. Gemma's position fails under both federal and state law, and therefore there is no harm under the law from this project. S11. Now going over to S12. Slides 12 through 14 refer to the legal maxim that is critical here. And you'll notice that both of the attorneys, as well as Mr. Gemma, avoided this key point expressly and continually. It's because they have no defense to it. But this is the key, at least a key, to the case under the Federal Fair Housing Act, which Mr. Higgins talked about, but Mr. Gemma avoided. So the Federal Civil Rights Act prohibits segregating disabled people, including those with dementia. And I'll just highlight a few of the principles. There's a lot of quotes here, but they're all different, but they're also related. So Mr. Gemma's position is discriminatory, and it's impermissible to consider the township cannot legally segregate disabled people who need dementia. It's very clear from the 1968 amendment to the Civil Rights Act. It included people with disabilities as protected individuals. Now, it's like racial discrimination in terms of the impact and remedies, and so this powerful statute provides for damages and attorney's fees, just like racial discrimination in housing does. And it applies to considerations by boards and municipal bodies and the like. Going over to slide 13, the law requires what you've heard Mr. Higgins talk about, reasonable accommodation in enacting and interpreting zoning ordinances, including variances like here. The Act requires that those with disabilities must be provided with the same opportunity to housing as those who are without disabilities. Slide 14, the Act prohibits laws which limit the ability of those with dementia and other disabilities to live in the residence of their choice in the community, not the choice of the municipality, where they want to live. It's very clear under a myriad of different cases over the decades. And to say it from another legal point of view, they have to have an equal opportunity under the law to decide where they want to live, and in this case in Holmdel. Slide 15. Now, Mr. Gemma's position directly violates the Act, which is a declaration the handicapped be free as anyone else to choose where to live. If you want to live next to the development, if you want to live where the farm is now, you have the right to do that. If you decide you want to live on the Route 35 corridor, you can do that too. Granting our requested use variance will save Holmdel's ordinance from federal challenge. An otherwise discriminatory ordinance can survive challenge if it's modified. So the accommodation in this matter, under federal law, is for the variance to permit this use, which we've described to you at length, and particularly its ancillary buildings and parking in the R40B zone. I'm going to skip S17. It wasn't raised tonight. I am going to bring up on the next few slides, and very quickly, about the Brightview project, which was mentioned many times by the experts for the objectors, but also by some members of the public. So as we've heard repeatedly, the Brightview project was granted by the Planning Board of Holmdel just a few months ago. And some indicated that that's a reason to deny this project because there's a lack of need in our area. This is factually and legally incorrect. There was extensive testimony on the great need for the enclave. Also, when the state issued its CON for the enclave in 2021, it concluded that there was a need for the project for the 105 residents approved. Now, it was a year later, this year, when the state issued its CON for Brightview for its 38 dementia residents in the same region. Still a need, definitely a need in 2021, and that continues today as a matter of statutory right, regulatory right under the CON. So slides 18 through 20 provide comparisons of the differences between the two projects. And you can look at that very quickly, but you'll see that the Brightview is in a much denser area, which has a massive three-story monolithic institutional structures compared to the low-scale residential village of the enclave. And you've heard council tonight say, well, you know, it's very intense. Well, you heard extensive testimony from the applicant about how it's aesthetically pleasing, and it also is low in density based on the zoning. Now, slide 21, very briefly, it shows you that the enclave will have far less impact on the surrounding neighborhood and general community than the other project. What's crucial, in part, in looking at these last three slides, is that residents have the right to choose where they want to live. On slide 22, the Brightview resolution includes that it will have wide fire lanes, and the traffic from the facility will be light compared to the existing traffic, and you've heard that in our case. So there are some similarities which would be reflected in the resolution if you deem it to be provided. And since Mr. Flegel prepared the other resolution, I'm sure he can insert that in there very quickly. Now, you heard a lot tonight, almost exclusively, about the MOUL, the SECA test, and that's what I'll go into quickly now. Slide 23 is the entrance into that discussion. We have a right to receive the use variance. Slides 24 to 26 highlight that all experts agree that the positive criteria under SECA has been met by the applicant. So you heard Mr. Asada say, well, maybe that's true. It is true. Everybody agreed to that. There's no question about that whatsoever. Moving through 26 and now to 27. Kate agreed with Jim Higgins that there is no need to grant a bulk variance for impervious coverage. Now, of course, this doesn't deal directly with SECA, but I'm including the other relief that's requested. There's no need for any bulk variance from our point of view, but you might consider a minor variance for a sign and a design waiver for trees, which we contend is irrelevant based on past discussion about that. But they would all be subsumed, as Mr. Higgins discussed, which was not disagreed to by any expert. Slide 28. This inherently beneficial application does not require the applicant to prove particular suitability, which you might consider in other types of applications. I mention it because on slide 29 we point out the details about how the facts clearly show that such suitability does exist, and that's relevant because it enhances the benefits and the reasons to approve the use variance. I'm going to skip 30 for brevity, going over to slide 31. So This shows the standards. Mr. Asadi and Mr. Clancy properly pointed the burdens of proof out to you. There must be substantial harm. There is no substantial harm whatsoever. So on 32, as to the first prong, the applicant's witnesses all testified to the great benefit of and the need for the project in the area and as determined by the state. Interesting, Mr. Asadi really only talked about his planner. Remember, there was another expert. 50% of their expert testimony was fully in favor of this project. In fact, Joel Winter, their own expert, praised the great benefit of the project design, especially related to the Huckawick standards. That's on slide 32. And if you go over to slide 33, she also praised the quality of care by staff at facilities such as the Enclave. Cindy Jakes, one of our VPs, testified several times, and at one point she testified about what we call the Renowned Tapestries program, developed with the Alzheimer's Association, which is a key to the success of the operation of the Enclave. 34, it just shows that even Mr. Gemma praised the Enclave, and you have some quotes up there from the transcript, from the testimony, and he agreed to Ms. Winter's conclusions. Slide 35 goes into the second prong, detrimental impacts. As you heard at the July hearing, all of the immediate neighbors strongly support our application, and that's very relevant in terms of the law. So under the Cox Treatise, I quote, "If a close neighbor is supportive of a variance request, this is a fairly strong indication that the granting of the variance will not be a detriment to the public good." And all four of those immediate neighbors gave you many reasons, far more eloquently than I could have, as to why this project is beneficial and why it should be granted. Slides 36 through 38 list some of the important examples of why there is no negative impact, and I'll ask Ryan here to go through one to the other. I'll give you a little time to soak that up. I won't spend much time on it. However, when you get to slide 39, and I'll just look around to make sure folks have gotten to that. You can either nod at me or do something to indicate I should move on. All right, Mr. Burkle, all right. Mr. Flieger says move on, so that's good enough. So you heard council indicate that there's a negative impact because of storm sewer. Absolutely not correct. Hal Semoff testified at length that the stormwater system fully complies with or exceeds all relevant state regulations. The rate of runoff after construction significantly exceeds all standards. And despite the assertions to the contrary, the fact is, as clearly set forth in the testimony, no runoff goes to Wackack Creek. So there is no downstream impact caused by this. And this is especially at the June hearing, when that was testified by Hal, and there was some back and forth between Hal and Mr. Mellon and the chair on that. On 40, just to note that if there is an increase in rainwater over time, certainly the way the site is developed will have less of an impact than current conditions. And S40, we can just skip by that. It just indicates that you only have expert testimony as to the fact that there are no negative impacts. So any commentary by non-experts in a situation like this really can't override your expert testimony. Going over to slide 42 regarding the third prong of SECA, 9 of the modifications for mitigation by UMC are listed. We could do more, but these are the ones that came to my mind as we prepared this. So we responded with your comments over the months, and that's resulted in a final plan, which I hope you agree is more aesthetically pleasing and safer. We feel that we made all the changes that were requested to make it better looking to have a lot more landscaping, and we submit that the end result at least is not a detriment under the standards of SECA. And overall, we thank you for your assistance in raising the bar on this project. And now to the fourth prong. In this case, the high benefit far exceeds what we submit are non-existent impacts. Again, Mr. Gemma's one contention was about zoning. That's an illegal and discriminatory point of view. And now to the all-important burdens. You indicated, you heard from the attorneys that we didn't meet our burden, but there are two burdens here, and it's very critical to know the difference. I started with the Fair Housing Act, and under that federal protection, the burden of proof is not on the applicant in the end. It is on the objectors. You heard no testimony to the contrary, and they have failed to prove that our requested accommodation is unreasonable. On slide 45, that goes to the standard SECA MLUL burden of proof, and we clearly have met that burden as is indicated in part on that slide in front of you. Going over to slide 46 and begin this summation here. Therefore, the board's decision under the law as to the use variance is a relatively easy one. You heard counsel indicate the contention that there may have been a need for multiple variances. Recall that that has been discussed many times by this board, and I call your attention to Kate, who indicated that that is not so. She indicated that one variance is needed, not multiple ones, as was contended by counsel. So as to the one use variance that has been articulated, the test is this. Is there a significant negative impact from the project that would justify outweighing the undisputed high benefit to the public and the undisputed civil rights of the project's disabled residents? And we submit to you that there is no such impact. And even if there is, it's not significant. And therefore, the use variance must be granted. And to wrap up the relief, if you look at the slide 47, we detail how all the other requested relief should be granted for the reasons set forth. So to keep it short, as I know I need to, I just would like to finalize by thanking you again for all your efforts over this long period of time. We much appreciate it. And we thank you in advance for abiding by the mandate that you base your decision solely on the evidence and not my assertions of what counsel is claiming about what is said outside of this room or influences. That's completely irrelevant. You base your decision on the evidence and not on popular opinion or on legally improper or factually irrelevant conditions or contentions. So we hope you agree that the enclave will be a great asset for Holmdel that will provide for the present and future needs of the community in this location, as we've discussed with you for a long time, and as the law permits. And again, if you have any questions, I'm happy to answer them. Otherwise, you can ask your professionals during deliberation, but thank you.
Thank you, Mr. Brown. In that regard, do any of the board members have any questions about what we've heard so far this evening? A moment. None, then I'll turn to our professionals. Kate, would you please summarize some of the issues from your perspective?
Sure. Going to address a couple items. Some of these you've heard from me before. Some of these are contained in my report. If you would just hold on for one moment. I'm going to start with the, Okay, I'm going to start with two pieces of case law that have been discussed over the course of this hearing, and that were both mentioned briefly in Mr. Brown's presentation that he just gave. Then I'm going to reiterate again briefly the standards for a use variance under SECA that you've heard, and kind of try to tie these together, and please feel free to ask questions. The first case that I will mention is the case that Mr. Gemma, the objector's planner, brought up over the summer, which Mr. Brown mentioned that at the time of the hearing, both Marty and I, agreed, we thought it lacked relevance to the case at hand. This is the Dover Township case that was mentioned. Since then, looked into it a little more, and since it is on the record from the applicant's objector and it was mentioned here, I just want to reiterate that I agree, with what I said previously, which is that I think that this case does lack relevance in this situation. And this was a case where, and interestingly, this was in the township at hand. This was done prior to the effective date of the municipal land use law, but it was decided after. So it does have it's easy kind of to track it to modern land use laws in New Jersey. But essentially, the municipality's governing body attempted to sue their zoning board for granting a use variance that impacted a very large portion of the municipality, basically by saying that they usurped their judicial power. And in that case, the court said, essentially, this is a touchy subject, that, there's no right or wrong, it's hard to tell, we can't tell you when it's too large in every case for a use variance. In this case, they said that in a lot of ways the zoning board had usurped the authority, but that was for several specific reasons, one of which was tied to the size of the tract of land, the percentage of the town, and the percentage of the zoning ordinance that it encompassed. And then also the fact that what they did was that the zoning board at that time, as part of their decision, they decided to apply the requirements of a totally separate zone to this entirety of this existing zone, basically. So that's something that the courts determined was very close to a legislative rezoning, and that in and of itself usurped the governing body's authority. However, what we're looking at here is a case where we have a property that is a small percentage of the R40B zone. It's an even smaller percentage of the township, and it really impacts only it's two pieces of property, maybe three technically because of the farm assessment, and that's really stated, and this is from this decision, where they state that, the way that the MLUL reads, where the zoning board's power is really intended to apply to specific pieces of property. And in my opinion, that's what this applicant is for. And so I don't think that I don't think that this case has bearing on the decision at hand, and I think that this is the proper application of a use variance.
Going further, if I may, for Kate, there was an implication that by granting this use variance, it changes the zoning for all R40B properties, and that's not the case.
Yeah.
Any decision here just applies to this property and to this property only.
Yes, and just to look at this case law in particular, the standard that they use is the basic inquiry. It must be whether the impact of the requested variance will be to substantially alter the character of the district throughout the township. That's the entirety of the district. That's the entirety of all R40B zones in the township. And, I think and honestly, in my opinion, the fact that this is an R40B parcel that's not connected to any other parcels almost negates that in its sense. We're not saying that this is not it's not saying that this property is not appropriately zoned, but it's not, just the idea of a use variance for anything, not necessarily this one in front of you. Again, this is an appropriate, in my opinion, this is an appropriate use of that, the board's power to grant variances. So the next item is the just the recent case that was brought up with regards to the Federal Housing Act in general, and particularly the Blake Gardens case, which has been discussed several times over these proceedings. And that's in reference to the fact that the state of New Jersey, a couple years ago, about six or 8 years ago, changed the municipal land use law to eliminate dementia and Alzheimer's patients from the category of persons with head injuries when it came to the location of housing for those folks in single-family residential zones. The type of, they're basically referred to as either group homes or, the type of maximum of 15 bedrooms, et cetera. So I think, and that was brought to federal court under the Fair Housing Act, where it was determined that because requiring a use variance specifically under state law, requiring a use variance exclusively for dementia patients or Alzheimer's patients versus those with other head injuries constituted, let me get the phrasing right, constituted disparate treatment of a person based on their disability. So the two,
Just to clarify, that was for an individual house with multiple bedrooms as opposed to the type of application that the applicants got, right?
That's exactly where I was going. Yes, thank you. So the case there, and and this has not been dealt with as a precedent for future things at this point, to my knowledge. So we can only work with this application here and how it applies to the state. So this applicant, they brought this up. They brought it up, the potential of what could be located on this site. But the fact of the matter is that they are not proposing a home for people with 15 to 16 people with dementia. And this is a site that requires a use variance. This is not a site that permits multifamily housing, et cetera. So, there are interesting considerations of that. And I think that if the board wants to look at how, just from the board's perspective, thinking about what could go on the site versus what is being proposed here, it does add an extra factor to that. But this case in particular, not to speak of the entire Fair Housing Act, but this case in particular does not, it does not have a direct precedent, in my opinion, to what is being proposed here.
Can I ask another
Sure.
question? So, this property has a commercial component that's a pre-existing non-conforming use, right? So therefore, if the applicant stopped using this for commercial purposes, right, there's a pretty strong argument that they've abandoned that use and that commercial component no longer exists.
Yes, I would have to look at the ordinance has a time frame on it. It's usually approximately a year. But yes, that's typically a pre-existing non-conforming use is determined to be abandoned after a certain amount of time.
And when you talk about all these commercial possibilities, in actuality, none of those exist. This is a R40 zone, so this is about what you can do with this from a residential perspective, not from a commercial perspective.
Yes, I think the alternative uses that people have mentioned here have been things involving larger municipal buildings, larger types of farm equipment that could be located on the site. There can be commercial aspects of a farming operation that are associated with that would be permitted on the property. But yes, the existing use as tool rental, equipment rental, et cetera, can continue. They could not expand without coming to this board, and they could not discontinue the use and then try to come back in the future after X amount of time.
But to expand on a little bit what you said, farming is a permitted use.
Yes.
And so any kinds of things such as larger barns associated with a farm would be permitted.
Larger barns would be permitted, a variety of different types of equipment would be permitted. The township ordinance allows certain types of farm stands, farm stores, et cetera, in residential zones that are associated with the farm as well. And that's separate from anything that would be protected under a right to farm act.
Let me just clarify Val's point. There's no bright line number of months or years for abandonment. It's case by case.
Okay.
Intent. And you have two components there. You have the old retail sales, whatever you want to call it, repair, and you have the current mulch, which I think is still going on. So I think you have to distinguish the retail side from the mulch side. Just if you're factoring, you know, that
Well,
into
in-
it.
in
Just
this-
so we're, you know, we're not have an improper record.
I'm not gonna,
Yes. Thank you.
I'll wait till we talk,
That's fine.
because I don't wanna keep.
Okay.
going, keep-
No, it's okay, and I apologize for the misspeaking about the time frame for abandoning a use. But yeah, but both of those uses are, as Valerie mentioned, those are both technically commercial uses. You know, one might be more impactful than the other, but yes. So then just lastly, you know, I just want to reiterate the criteria that we have heard before for an inherently beneficial use under the SECA test. I'm not going to go into it too much. You've heard it from me. You just heard it partially from Mr. Brown. But again, you know, this type of use, senior housing facilities, have been deemed inherently beneficial by New Jersey courts. And specifically, the court found that this proposed use advances one of the purposes of the MLUL, which is Purpose L, which is to provide senior housing for throughout the state. And that, you know, that's really the issue. That's really the case of if the board determines that this is an inherently beneficial use, which, you know, in my planning opinion, there is precedent that that would be determined to meet the positive criteria. So then, when you're looking at the rest of it, that's when you look to the 4-part balancing test, identifying the public interest at stake and ranking the use, how much you think that this use, how compelling this is in terms of the public interest, identifying the detrimental effects, determining whether reasonable conditions can or have been implemented to mitigate those effects, and then you balance A, B, and C, really. You know, and to determine whether the granting of the variance would cause substantial detriment to the public good. So they also have to address the negative criteria, but the enhanced quality of proof, where you have to prove particular suitability for a site, and you also have to reconcile the granting of the variance with the fact that it is not permitted in this zone, that's overridden by the fact that if the board does determine it is an inherently beneficial use. So, you know, I'm happy to answer any questions. I know we have talked about it before. If the board has any specific questions about those, the seeker criteria as you're deliberating, I'm happy to discuss that as well.
Any questions at the moment for Kate? Bob?
Thank you, Mr. Chairman. I think during the course of the various hearings, there have been a couple of engineering issues on which the board and some of the comments spent a lot of time. One of which is sanitary sewer. So as was mentioned several times during the hearing process, the board's jurisdiction is essentially limited to on-site sanitary sewer issues. Any sanitary sewer issues off the site would be under the jurisdiction of either the township engineer and or Bayshore Regional. And that's the sanitary sewer issue. The other issue on which we spent quite a bit of time is stormwater. And from a stormwater perspective, the applicant has made extra efforts to comply not only with the DEP regulations that were in place at the time of application, but also with the DEP enhanced stormwater regs that were put in place after the application was submitted. So they've addressed those new regs by providing green infrastructure. So there is impervious and pervious coverage on the site. But from a stormwater rate reduction runoff perspective, being an engineer, I'll just give you the numbers. So the DEP regulates 2-year, 10-year, and 100-year storm. And DEP requires that you reduce the off-site runoff rate by certain percentages. So for a 2-year storm, the DEP requires you reduce your runoff rate by 50%. The applicant's runoff rate reduction is 67% for a 2-year storm. For a 10-year storm, the rate reduction requirement is 25%. They've reduced the runoff rate by 52%. And for a 100-year storm, the rate reduction requirement is 20%, and the applicants reduced it by 42%. They've done that through complying again with green infrastructure, the stormwater management rules, bioretention swales, rain gardens, and it's really in a better situation than it was before. Bottom line also is that we're used to have a substantial amount of runoff under existing conditions directed towards Wackack Creek. That volume is also reduced, and that's based on direction from the county, that it be directed towards an existing infrastructure heading down to White Road. But again, the volumes are all, and the rates are all decreased substantially.
So the comparisons you're making with what's today, the way the property is now, and as a result of the proposed development, what the situation will be then. And what you're saying is that all the calculations and the design is such that it will significantly reduce the runoff compared to what it is today.
The runoff rates are significantly reduced, yes.
But still we get it wrong sometimes, right? Like Palmer Avenue, the Palmer Square project, where there's intense flooding now, right? Where the experts, obviously, I wasn't at all involved in that project, but clearly there was planning testimony, there was engineering testimony, there was municipal involvement, and still, after all of that, we built a housing project that's completely flooded an area and caused extensive problems for the residents, right? So despite the best laid plans, right,
When was that
we get it
built?
wrong. Right?
When was that built?
Can you move the mic closer, please?
Yeah, I can't hear the mic closer. Usually a big piece of being very loud. It definitely had to have been built in the 80s because possibly into the 90s, actually, because I wasn't there when I was a kid. So I'm thinking that was, might not be
It's actually, the red light is on.
Mine's staying on.
Oh, now it's on. I think it's on now.
No, it's not staying on. Okay, I'll hold it. I think Palmer Square had to have been built in the 90s. Does anybody know? I could look on the tax records real quick, but I'm pretty sure.
Yeah, but that's long before any of the current state stormwater regs.
Correct.
So there's very limited infrastructure in that development?
I'm not in that development. I don't live on that side of
Yeah.
town, but knowing from hearing the complaints of residents and listening to things that the residents say, that whole side of town is huge flooding issues that the township is constantly trying to deal with.
Correct.
And my only point is this. Our great mind, and I don't mean that as an insult, our experts, our educated people all weighed in on that project, all thought they had solved the flooding issues. We have flooding issues. In fact, I know that's a deep concern of yours, and how many times I've heard you personally mention stormwater management regs.
Right.
I can almost
But I
hear it in
think,
myself.
and in fact.
So I have concerns about what we're doing on this property, and that's not to say that we're not ameliorating the current situation. I take your word for that, Bob. You're our engineer and I trust you. But I also know that experts don't always get it right, and that just because an expert is telling me something doesn't make it so. No disrespect to either one of you that I know always tell me what's right. So it's just a point. The government doesn't always get it right. The experts don't always get it right. And sometimes, no matter what they plan, we still have a condition we didn't plan for. And that area, that whole corridor there, that Van Schoik Laurel Avenue corridor, is already right now has extensive flooding issues, right? Made far worse, thank you, Middletown Township, by the installation of 160, I think, further townhouse units in that corridor. So there are big flooding issues there.
And the township does have a study going on, and
Yeah.
Mr. Mullen's been involved with that, and the results will come later. They're starting by GPSing, surveying all the existing infrastructure.
But we don't have the benefit of that for
No,
deciding this
correct, but
application,
The one thing that we did have, the preliminary Rutgers study, which their tentative conclusion was that the problem in the Palmer Square area was due to upstream coverage. And it's not just so much the Palmer Square design itself, but there was too much water coming down to there. So there've been a variety of discussions, but You're right.
coming down to there from where? From Laurel
Further up.
Avenue? Well,
No,
that would
from
be
the
further up.
Further upstream, including the Tacaloosa area.
Right, but this is all upstream of that.
Correct.
Whole
Water-
area. So
yeah.
this is, that's kind of my point, right? That this is further exacerbating that any development that we do up in this area is in that direct line to further exacerbate the flooding in the Palmer Square area.
Although the one key thing is the county required this applicant to redirect all off
Towards Dwight.
towards Dwight. I don't know what stream system that goes to or where it goes, but that it
Nut
takes.
Swamp, is it Nut Swamp?
Yeah, something like
Nut,
that.
I think it's Nut Swamp, yeah.
But it takes it away from going down the Horace Way Cake.
Mhm.
So it'll provide a little bit of relief.
I don't think we should have any, I think once we start letting Mr. Brown comment, then we have to let Mr. Asadi and Mr.
Yeah,
Clancy
okay, we'll
comment,
just
so.
hold it.
I think this is our discussion now, Mr. Brown, with all
Right.
due respect, and that the applicant's not involved anymore.
Okay, Mr. Bob, do you have any further comments
No, not at this time,
at
Mr.
this
Chairman.
time?
I'll be happy to answer any questions you
Okay.
may have.
We'll turn to our attorney. Marty, you've been keeping notes rigorously, relentlessly throughout this whole process. There have been a number of times where the applicant and the board have agreed on a certain condition, and we should all at least get clear on what the list of those items are.
There's only one problem, that list is sitting on my desk. However, we never usually put them all on the record. We have about 20 conditions that we've agreed to, and the applicant has agreed to. I just finished writing them this afternoon in the event we needed them. There's about 20. The biggest one is the closure of Country View Lane, as long as the township agreed with that. There's the landscape easement. There's probably about 20 of these conditions. They will, as we always do, we will put every condition in the resolution, even if we miss one while we repeat it here. But I do not have this specific list here. It's sitting on my desk. I cannot give you that right now.
Okay, are there any other comments you would like to make,
No,
advice to the board?
I will compliment this board for listening through, this is the 13th hearing, there was an on-site. I'm immensely impressed based on, if anybody had a legal question, they asked it. They weren't afraid to ask it. And I think this board is focused on what they need to do this evening, and whatever their vote is, I just must compliment each one of us. I mean, it's more than we've ever done for a hearing, and the questions that I've been asked for legal questions have been more than, if ever, asked on any application. So that's commendable, and that's what our job is, right? That's what your job is, so that's a good thing. You've heard that a lot of this is going to boil down to the SICA test. You've heard it many times. I don't need to repeat it. It's the balancing test. As long as there's a finding of inherently beneficial that satisfies this positive, which I agree with Kate on her analysis. So at this point, I think it makes sense to have a discussion of where everyone is, and then, move for approval or denial based on that discussion.
Okay, so it's time for board discussion. We each need to put on the record some of our considerations, both pro and con, as input to Marty and an eventual resolution.
Yeah, Mr. Chairman, I guess I could start.
Go ahead.
I'll just cut it off 1 second.
Go ahead.
You're exactly right. That's where I went to. Everyone knows, they've been reminded of the legal standard, you have to make findings of fact, and then we'll make conclusions. So it's important that we just don't vote yes or no, because then no one knows what we're thinking, other than some comments made throughout the hearing. So, you don't have to have a very lengthy, but it's important that some comments are made as to where your thoughts are. And so this is actually a very important part of, one of the more important parts of what we're going to do tonight.
Jason?
Can everyone hear me? So mine will be somewhere between Mr. Asadi's and Mr. Brown's statement. I wrote up a few things here based on the last, 10 months I've been sitting on this board. To start out, just a little bit about me. I moved to Holmdel a little over 10 years ago for many of the reasons everyone sitting in this room did, as well as my fellow board members. The bucolic nature of Holmdel, its farms, its open space, its parks, its school systems, its sports programs, and the good families we all call here neighbors. Coincidentally, 10 years ago, Bill Potter decided he wanted to sell Potter Farms. May he rest in peace. In my opinion, one of the strongest principles of America is the concept of private property. No one can force you to do something with your property, and no one can stop you from doing something with your property within reason. An ideal that provides landowners with the ability to sell your land at the time of your choosing, and hopefully for a profit, is part of the foundation of the American dream. To help keep the balance of development and open space, the taxpayers and neighbors have options. Holmdel has wealthy residents who can buy private property and donate it to the town for preservation. We have certain private organizations that can also organize and fundraise to purchase and preserve land. We have the county who can buy land and preserve it for open space. We have the town who could declare eminent domain and purchase the land with public taxpayer support and bonding. For 10 years, no one did anything. Bill Potter eventually did find an interested party who signed a contract to purchase the land from him and intended to build high-density housing. Some of you may be familiar with the term COA. I think we've talked about it a couple times, or the Council on Affordable Housing, COA units. The residents of our town were very concerned about this possibility, and there was a very loud outcry from the residents and taxpayers that persuaded the potential new owner to simply walk away from the contract. And by doing so, allowed a new, different opportunity for the land to be sold to a somewhat unique private institution, and this time it was called United Methodist Communities. The previous developer, who had signed a contract with Bill Potter, was seeking to challenge Holmdel to approve and include another phrase some of you may be familiar with, the Mount Laurel affordable housing, and potentially could have been allowed to buy by the town and existing zoning regulations to build these high density housing units. United Methodist Communities would instead like to build a 105-person memory care facility to house people with dementia needing limited care but unable to live 100% alone. It would involve the construction of 15 buildings divided into households with 7 residents each, about 85,000 square feet of buildings on 18.5 acres of farmland. It is estimated to cost tens of millions of dollars to build such a state-of-the-art facility in Holmdel. The previous developer, who, if he went through with the original contract, could have been challenged and was in fact intending to challenge the town to include this site in the affordable housing requirements for Holmdel, which allows high-density housing, and was debatably within their rights to do so. They could have built this high-density housing without any valid challenges from this zoning board. On the other hand, what United Methodist Communities needs from this board is what we refer to as a D1 variance in order to build this assisted living facility, because it is not traditional residential, but multi-use, and this has come up a number of times, with commercial aspects. We understand this, a hair salon, a deli, a movie theater, etc., on its property for these 105 patients to access, and yes, perhaps their families. UMC received a certificate of need from the New Jersey Department of Health, which allowed for the project in the region due to the rapidly growing elderly population in New Jersey, particularly in Monmouth County, and including those eligible for Medicaid, estimated to be about 10% of its residents, which will support some of Holmdel's affordable housing obligations. This center would serve Holmdel residents and those in the surrounding communities. Some say that Holmdel doesn't need additional living facilities. We've heard that twice already. That there are 6 or 7 other facilities in Holmdel that offer similar related services, and that should be sufficient or enough. The testimony I've heard stated that 32% of those over 85 years of age will develop some form of dementia in their lifetime. America and Holmdel have an aging population that will need to be taken care of. Maybe not today, but not too far in the future. The question that is put before this zoning board today is this: is this an inherently beneficial use to Holmdel? Not Middletown, Holmdel. Does the positive criteria outweigh the negative criteria? It seems obvious to me from all the testimony we've heard from the planners, the applicant, and public comments. We've heard a lot of public comments. Do the benefits outweigh any detriments under the SECA balancing test? I do believe the detriments have been minimized and overcome by all the reasonable conditions, and this is very important. I will make sure that Marty and I, there's at least 20, and I've talked to Marty a number of times about this, but they're reasonable. Reasonable conditions set forth by this board and outweighed by the benefits as we determine and come to a decision for this under the SECA balancing test. This is the law for the public good without substantially impairing the intent of the original zone, and this has come up as determined by the master plan of Holmdel. I am acknowledging that. We've heard testimony from some that this would change the character of the neighborhood, that this facility would be detrimental to the surrounding neighbors. However, the three most impacted neighbors, and I think some of them are here today, whose backyards face this facility, have given absolutely complete, unfettered, unquestionable, and undeniable support to this zoning variance and have strongly stated that they believe United Methodist Communities would be good neighbors to have. UMC went so far as to agree to deed restrict the land to ensure road access would never be permitted through the Country Woods community. And this was a critical condition to the three immediate homeowners. We've heard this a number of times, which is somewhat ironic because I think in the last meeting, maybe 2 meetings ago, one of the last objectors from the public instead suggested building a new development of 7 or 8 family homes in a cul-de-sac with access running directly straight through Country View Lane, like as if they didn't hear this throughout the last 10 months. So I thought that was an interesting objection. Okay, so UMC has also agreed to every single request the board has taken, the board has asked regarding the landscaping, the tree coverage, enhanced tree buffering on all sides of the facility so that we're not going to see a lot of it. And has also agreed to self-imposed requirements to permanently maintain the landscaping. And we will make sure that this is enforced. This is our job. Township. And begin planting. This was one of my first meetings here back in January where they agreed to this, and begin planting the landscaping prior to the construction even commencing, so that it would give the trees time to mature and grow and start covering the buildings that will be there. UMC also agreed to increase the setback required by the town even further from 25 feet to 100 feet. And I'll get to why that's important later on if we were to build single-family homes. I'm almost done, another page or two. We've heard testimony that the impervious coverage from all the pavement, parking, and driveways, and this is my big thing, the flooding. I think I share this with some members on the board. There's a huge flooding problem here in Holmdel and Monmouth County. So we've heard testimony that the impervious coverage from all the pavement, parking, and driveways would cause flooding issues for the downstream communities. That's important to me. I do not want to cause more flooding in our community. UMC has gone far and above and beyond, actually exceeding stormwater regulations with actually displacing more water, and you heard this from our engineer today, by displacing more water drain off than currently occurs today on Potter's Farm. Indeed, a large percentage of the water, the collected water is going in the opposite direction of Palmer Avenue to Valerie's Point. Towards Nut Swamp, which is in the direction of Dwight Road in Middletown Township, which was approved, and this is not something in Holmdel's, but this is approved by the county and the state. It is revised and adjusted originally planned blacktop parking lots into stone lots and paver parking areas, and then banked parking spaces for the future. There's grass right now. It has gone far beyond what the Department of Environmental Protection has recommended with regards to detention basins and rain gardens. And again, we've heard from Mr. Mullen that they've done this, and that's the intention. They are installing New Jersey DEP suggested green stormwater management to aid in additional drainage to prevent downstream flooding. Again, my concern. This will tie into the existing sewer lines, avoiding any potential flooding issues for the immediate area. We've also heard testimony that this facility is not suitable for this area. And I've struggled with this issue, because I know senior care facilities were planned to be over on the other side of town on Route 35. I definitely understand that, and I'm not ignoring that fact, and I struggle with that. What I've thought through is that smaller lots of land with the required setbacks that are needed on Route 35 would pose a challenge for a facility of this unique style and size. I also believe any perceived traffic issues would be far better managed with the close vicinity of exit ramps to the parkway in both directions of particular care for special reason. It is particularly suited for this location rather than an already congested Route 35. We have heard, and from my fellow board members, some of whom are not here right now, we have heard concerns from the community on the increased stress this may place on our police, fire, and EMS services. To address those concerns, UMC has agreed to make changes to the structural layout of the facility to allow more efficient and safe access to all parts of the facility. At one time, and I'm looking over at UMC, and I still hope, UMC has also generously offered to make an annual donation to the town. If this will still be donated, this should help cover increased costs for the anticipated increased EMS needs and related costs that its senior population may require. The testimony we have heard leads me to believe any lighting and noise issues would be insignificant to the surrounding community. I think our neighbors that were backed up to it understand that and have given testimony to that. I also have heard nothing that concerns me with regard to the safety of anyone in the surrounding community. Any increased burden on the fire, EMS, and police would also be offset by a zero impact on our public school system. Last page, I promise. Yeah, perhaps, so I've heard this too from the community. Perhaps we could take a risk and hope that UMC might just sell to another developer. If we rejected this, this application for the variance and sell to another developer who could build 6 to 7 $2 million homes, and those houses would only have a 25-foot setback from the roads, much less landscaping, more lighting, more pools and basketball courts backing up to the existing Country Woods homes. Each home perhaps pays $40,000 a year in property taxes, could have 2 to 3 children who would attend the school system, which costs approximately $15,000 a year to educate each student, but would also have 2 to 3 cars per household making daily trips to work, school, and other school activities and sports and shopping and social activities, etc. I believe that traffic alone would be more detrimental, the key word detrimental, to the surrounding community and place more of a financial burden on the school system than what potential perceived burdens this dementia center would place on our other public services. Most importantly, we've heard from the 3 families whose backyard will back up to these 15 buildings, and they want this. They don't want something else. We've heard them. These are the 3 most impacted families in our town. UMC will be good neighbors to Holmdel. The site will be a greener, more environmentally friendly addition to Holmdel than some of the other alternatives, and we've spoken about the other alternatives. Much of what UMC has agreed to these past 12 months would be worthless if we denied this application and a subsequent appeals court overturned our decision. That would be far more detrimental to the surrounding community than what this good neighbor is willing to do today with all the conditions that they agree to be a positive influence and partner in our community. So in my opinion, the information and testimony United Methodist Communities has shared with the Holmdel community and this board is credible, and the statements in support of the homeowners for this variance, who also would be most impacted by whatever is constructed on this property, are also very credible. I believe this facility would promote the general welfare and overall community of Holmdel, without substantial detrimental impact to the surrounding community and the overall character of Holmdel. With this being said, I am inclined to vote yes that the Dementia Center Dementia Care Facility proposal from United Methodist Communities is inherently beneficial to the residents of Holmdel, and in weighing the detriments versus the benefits under the SECA test, this should be approved, again, with all, and this is for Marty, I'm going to be really clear about this, with all the conditions the board has requested, with all the mitigating conditions the board has requested these past 10 to 12 months to address what we determine to be any negative detrimental impact. And I will cede the microphone.
Thank you, Jason. I'll pick up and offer some comments as well. I mean, some of this is going to get repetitive, and we'll try to avoid that a little bit. We've had a lot of discussion about what the MLUL says, and Kate's planning letter addressed that, and the SECA test as well, and the question of with regard to inherently beneficial and case law, and the court case indicates that senior care facilities are inherently beneficial. As the population of Holmdel, Monmouth County in the USA ages, there's a need for such facilities. I am very intrigued by this proposal for a better facility for seniors with dementia. Instead of just warehousing the patients, I mean, we saw briefly something about the Brightview thing on Route 35, and it's like 35 or 40 in one wing of a large building. That's like a traditional hospital wing. It's not a state-of-the-art residential facility with innovative programs where you're living in something like a house. I feel that extra credit goes to UMC, the applicant here, for seeking to provide our seniors with not just adequate care, but much better care. We've heard reference to the Federal Fair Housing Act, and it requires that we make reasonable accommodation for handicapped people, and I'm not going to get into definitions of handicapped and dementia and all of that, but to live in a residential zone of their choice. And it's illegal to require that such housing be limited to particular zones such as a commercial or highway zone. In my opinion, this property meets the requirements of putting residents who need care in a residential zone. Testimony was given that the small size of the current property is such that it's no longer financially viable as a farm. It had been a much larger property in decades past, but what's now, it's down to 18 acres, and that's for general farming is not really viable. Indeed, the existing zoning would permit large commercial farm-related facilities on this site. Also, New Jersey law provides, as I think Kate mentioned, that 7 group homes for 15 persons could be built on the site. I think the dementia proposal is less intrusive and more compatible with the rural character of this area. It's designed as a low-rise residential facility. Most of it is 1 story. There's a couple of buildings that are 2-story. It's consistent with the adjacent residential neighborhood and would be inconsistent being surrounded by big box stores on Route 35. Moreover, it's been mentioned also tonight that Joel Winter, testifying for an objector, described the proposed program as fabulous. So I feel that this use is inherently beneficial. It's for a residential use in a residential zone and an appropriate use of the site. And as we've heard, the granting of this use variance does not change the zoning. It only permits this particular use on this particular site. We also need to consider any of the detrimental effects of this application. As has been mentioned, we've spent many hours considering the proposed site plan and potential negative impacts. Topics considered include access for emergency services, fire, ambulance, buffering to nearby residences, traffic, parking, noise, stormwater management, and more. In many instances, as mentioned, the applicant agreed to modify the plans so as to minimize and even eliminate the negative impacts. For example, the stormwater management plan significantly exceeds NJDEP requirements, and we've talked about before, and will result in significantly less runoff to the Mahoris than occurs now. Another item of concern was the coverage. This proposal is for 22%. It's been mentioned that this exceeds the 15% that's allowed for a regular residential development. However, also permitted in this zone and on this property is a clustered residential development. And for that, permitted is 25%. Neither the 15% nor the 25% number is directly comparable to the 22%, in that the 15 and 25% apply to what's on a particular residential lot and doesn't include any of the streets and sidewalks and other infrastructure that would be part of such a development. So I view this proposal actually as a form of a clustered residential development. The other negatives are mentioned are really mostly almost completely ameliorated and are very minor. As mentioned, the zoning board jurisdiction is limited to the site of the application. Off-site things should not be considered, such as connections to the township sewer system, off-site traffic, taxes, payments in lieu of taxes, staffing for emergency services. Those are all things that are under the jurisdiction of other entities, and here there would not be any impact on the school system, period. There were, at our last hearing we had, and one before that, we had public comment, which is a required part of this process. Some of the public comments were in favor, some were against. As noted, all of the nearby residents were strongly in favor and stated their concerns had been addressed by the applicant. And in several cases, they were very emotional in wanting this proposal rather than something unknown to any of us. Formally, the application does require some C variance relief for a couple of bulk items, but those are minor and are subsumed in the use variance by law. In summary, I feel that the Dementia Center will be an asset to Holmdel. The positives significantly exceed the negatives, and I will intend to vote yes. So who would like to go next? Gaurav? Well, he doesn't get to vote, but he still gets to be heard. He's a member of the board, and he can express his thoughts as well.
Sure. So thank you everyone for allowing me to speak for a few moments here. You know, I think for me there's a lot of personal thought behind it, as well as what was presented to us over the last 10 months or so I've been on this board. So personally, which has no substance here, but personally, I enjoy driving my kids to their practices next to a farm, to a land that's beautiful. That's what drew me to Holmdel. But again, this is not about what I personally like. It's about what's presented, what the current land is, was and now is. And so in terms of all the testimony that we've heard, I hear my fellow residents who are against this. But I also know that with everything that was presented over the last 10 months that I've been on this board, you know, Mr. Brown and his team has done they've done a very thorough job of explaining what exactly is coming to this area. And they've heard our complaints, our concerns rather, and I think they will move forward, you know, in a respectful manner. That being said, as somebody who is in healthcare, who has treated some individuals with dementia, as a medical student, as a dental student, I've taken care of people from, you know, the severity of their injury, you know, of not only their mental state, but also the physical ailments that come with it. I do have concerns. I do echo some of the EMS concerns, because I know there is a great deal of burden that population presents. However, that is also a responsibility, and I think if there's a mechanism in place that we can allow to kind of buoy those factors, I think that's going to be very critical as well. So, as of now, at this point, I'm in favor of the motion here. So.
Who would like to go? Francis?
Hey, I've been a resident of Holmdel for over 40 years, and I can tell you my intent here is to serve the residents of Holmdel, because that's where I think my passion is, but also to give a fair opportunity to applicants for developing land. The Potter Farm, I'd love to see it preserved, but quite honestly, that ship sailed a long time ago. Mr. Potter sold, I was around when I heard about the possibility of affordable housing being put there. I am concerned. I have seen what has happened to much open space here, what could be there. After listening to the testimony from many residents here, both pro and against, most of them that are against it, we're talking about preserving the farm. That's not something we can do anymore. That's done. The ones that were for it are people that are going to be most impacted by this development, the people in Country Woods, and they're asking us to approve it, and I'm hearing them. Then I've been hearing the testimony on both sides, and I must say, I believe that United Methodist will be a good neighbor to Holmdel. I have seen them, when we raise concerns on this board, I have seen them go out of their way to mitigate those concerns that would be adverse to our town. Just for some of them, the stormwater. CELU presented a statement about stormwater, and I'm hearing from our professionals that they have not only satisfied it, but they have gone beyond that. Landscaping, and there's been talk about, in the newspapers, about Potter's Farm was the gateway to Middletown and Holmdel. I hate to say it, and I don't want to insult anybody, but in the most recent years, it's not the most appealing look when I get off the highway, as opposed to the landscaping that United Methodist Church has proposed to put on this land. I think if it goes through as they propose, and I hope we're going to enforce our conditions, I think it will be beautiful to look at when you get off the highway. Traffic concerns. I was one of the ones that was very concerned about traffic, the parking. They made some conditions, made changes for the parking. Also, the proximity to the highway, I think, is actually going to lessen the effect on our town. People working at this facility, visitors, are right there by the parkway, and I'm hoping they're going to use the parkway to get in and out of Holmdel and not come through the streets of Holmdel. Not that I have anything against it, but Holmdel already has too much traffic. Stormwater, impervious coverage. If we get cluster housing there, the impervious coverage concern is going to be even worse than it is now. I've seen it. Applications come before us. We've got big homes being put on land that just to put in a pool or a patio, they're asking the zoning board for variances. If we put in housing there, I guarantee you, we're going to get variances coming through. You have a 5,000 square foot house, and I'm going to tell you can't put a pool and a patio in. I don't think that's going to happen. So I think we're going to have a problem with impervious coverage here. Let me see. As far as the emergency services and other things that might be taxing on this town, when you put in any type of residential housing, we know we're going to get 2 or 3 children in that family. They're going to tax our school system, which we're not going to. When you have 2 or 3 children, you're not covering the cost of educating those students. I have nothing against that, and I'm not discouraging that. But we have to look at that from a perspective. Let's see. I am concerned about if we deny this application, I don't want my name associated with, I denied an application, and later on in years, something else came in there. That's going to negatively impact Holmdel. So I'm looking at all of the facts that I look here. I think, and my concern, and I do appreciate the wonderful facility that United Methodist Church is proposing to put there. But of course, my allegiance under the jurisdiction of this board and everything is for the best interest of Holmdel. And I think any of the negative stuff that's been brought out has been mitigated by them. And I've, quite honestly, in listening, I have been quite surprised at how willing you were to listen to the concerns of this board and the residents that you would be impacting. And for that, I'd say I can't see why I wouldn't approve this development in here.
Thank you, Francine. Jill, Jean?
Yeah, I've been here most of this year listening to.
Let's switch underneath, it's easier.
Well, it's already put into the on position, so I don't know if it's going to be working or not. Oh, it's working now, but only when I put my hand on it. Yeah. Basically, it's a question of, is there a need? State of New Jersey says there is. I would have to say that that is an overriding point. Yes, we have an awful lot of assisted living in town. And so you could make an argument that we really don't need a lot more. But since the state of New Jersey says that this is a need, as a board member, I would have to say that we have to make that the assumption here. And as far as, so that's the positive that we have to take into account. And if that's met, then the question is, are there negatives? And so far as I can see, and everybody else has agreed on this board, and our planner and our engineer, that in fact the most possible negatives would be stormwater drainage, and that is going to be better, hopefully, according to the design, than it is now. So assuming that that is correct, which is what we have to assume, and traffic should be minimal, and I don't need a traffic engineer to know that. You could just look at the numbers here. It's not going to be major. And we're going to have a nice, what I think is going to be a nice facility there with very nice buffering. We won't have a group of buildings that are decrepit like we have now. We're not going to have a farm there. That's, as other people have said, that's gone. So basically, I would be in favor of this petition.
Jill?
So I feel strongly that there shouldn't be designated areas for seniors, especially those with dementia. I believe that this applicant has done their due diligence over the last year, longer than a year. And, you know, I know that things are not going to be perfect. I agree with Valerie. Their experts can get things wrong. But I believe that this facility, this location, would offer superior accommodations for our seniors. I think it's very unmatched to some of the other housing options we have for seniors. And so I also look at us as a country, and we really need to honor and put our seniors on a pedestal and protect their dignity. And so I hope that this facility can do that. You know, growing up, so, you know, just sharing a little bit, I was really blessed to be surrounded by my grandparents and 4 great-grandparents. So they shaped me. And they lived very long lives, into their 90s. And I believe that that had a lot to do with their physical environment and their diet. So, you know, my grandparents taught me to garden. They had chickens, they hunted, they fished, they made homemade food. And I personally believe that well-being is dependent on a great connection to nature. So come the day my 4 daughters put me somewhere, I want to make sure I can be in a facility where I can garden and be surrounded by natural environment, you know, seeing animals still. And so I do hope that that's one of the conditions that we can continue to put forth. You know, I understand that after it leaves this committee, it's not up to us the same way, but it is still a beautiful piece of land. And I just think that, you know, as seniors, they deserve to have peaceful views. They deserve to have the gardens. They deserve to live in a facility that would offer such things as homemade foods. You know, and that isn't really offered in a lot of those facilities. But I've also listened to the community, so I have heard you. And I thank you for coming, and I respect all of your concerns, but I do feel that after weighing everything, that UMC would be good neighbors. So, you know, having weighed all of that, I hope that this facility does honor our community. I hope that it honors our seniors. I hope that it most certainly honors the Potters family. My condolences to you. And then I hope it can provide a huge new model for seniors, because it's absolutely needed. I see a loss in the natural worlds as part of the problems that we have with our overall health. So I think we need to start looking at these models and seeing how we can create a better lifestyle for everyone. So I actually see this as kind of a nice marriage of meeting the needs of the seniors while also keeping our rural community. So, you know, my goal is to create less of an artificial experience for our seniors, really honor Holmdel, and give our seniors the best care possible in their late age. And that's my overall thoughts. Thank you. So I would vote yes.
Earphones or okay. Valerie, earphones, one of you, whoever.
You want me to go next?
Sure.
So I've been on the zoning board for 8 years, and I'm going to tell you this is the absolute hardest. And I've sat on some hard and contentious applications. This, hands down, is the hardest application I've sat on. I cannot tell you how many times in my own mind I've gone back and forth on this decision and which way I want to vote. And even today, sitting here listening to Mr. Clancy and Mr. Asadi and Mr. Brown and their arguments and my fellow board members, there are a lot of good points here. And obviously, there is not a way to make everybody happy. In fact, it's the hardest part about this, where you have members of your same community that are really divided in the way they want an application to come out. And so we've been sitting here more than a year now, right, Mr. Brown?
Started in September of last year.
Hearing this application, it's a little insane that we've been at this for more than a year. Probably the most moving things that I've heard during this application certainly have come from the 3 neighbors who live in the back. And you probably were the most eloquent of all the speakers that we heard, and your reasons are very strong. But you had other neighbors who came here against the application who, although they don't touch the back, they actually touch the sides. They're the neighbors right on the border of that. So although we didn't focus on them as much, we focused on all of you in the back portion of the property. But the neighbors on the sides had some really strong feelings as to why they didn't want to see this application come in. You know, I don't disagree at all that both the law and good practices have us wanting to have our seniors reside in the community. It's better for their health and their well-being, and they should certainly be part of the community. But Mr. Brown, this isn't really about the fact that we're not going to, it's really what I said to Kate Keller when she was giving her synopsis. This isn't that we're not wanting the dementia patients to be part of our community. It's really about how many people are going to be in this facility and what size this facility is. So this isn't a house or even a couple of houses where we have residents in the homes. If that was the case, you wouldn't have even been here, because the state would have allowed you to put that facility right into the community, and we wouldn't have had a need for a zoning application. The issue is the size of this, and I had started back when you first started this, and I've expressed my concerns that to me, this is too large for the tract of land that we're talking about. In fact, I specifically asked if you would cut it down by a building. And the answer was, well, we can't make this commercially viable if we do that. And my opinion and my position was, you don't have to cut the number of residents to cut the size of the complex. It's just too big. It's too close to the street where the setbacks are. Everything else in that area has a certain character and a certain look in terms of the single-family housing that you're dealing with and how far things are set back from the streets. Even Sloan Kettering, which is not in Holmdel, is set so far back from the road that you don't even know it's there. So we're really talking about putting this facility that you want to build front and center onto Holmdel Street. So it's really going to smack you in the face when you drive down that street. And I know that there was definitely a disagreement among board members about what was aesthetically pleasing, but to be very honest, I find the design that you're putting forth looks like army barracks to me. I know that phrase has been bantered around. It's like a giant stockade. And I understand that you're going to need to contain the community. And look, and it's clear that you're going to get your variance, right? The vote is pretty clear that the numbers are there and you're going to get your variance. Even if, regardless of how Irfan feels, the numbers are there already. So that's really clear. You're going to get your variance. And certainly you need to contain the residents so that they're not a danger to themselves by roaming onto streets or in front of traffic. But you just have this, it's going to look like a stockaded complex is what it's going to look like to the outside. So the idea that you're going to have this really pretty looking community, I don't see it at all. I just think you're going to have this giant, ugly, stockaded, barricaded complex sitting right there in the center of a highly visible area of Holmdel Township, and it really doesn't fit in that area, in that community, and it really isn't good for the residents in that area and for Holmdel Township as a whole. So I would ask you to rethink what this is going to look like. I get you're in the home stretch, but this is really a aesthetically unattractive complex that's going to go there. There are a lot of things that other board members and people said. Yeah, we all would have loved to have seen this stay a farm, but we had 10 years for somebody else to step up to the plate to buy this property. Holmdel Township, a no-show. Middletown Township, but not there. Monmouth County, where was any of the government to step up and preserve this tract for the past 10 years, right? Nobody was there. So the Potter family and the new purchaser, right? Holmdel Township is an area of people who hate to be told what to do, right? If there would be one characteristic of residents of this town, it's that we don't like government intervention and we don't like to be told what to do. So it really is, I'm a no vote on this, but I'm telling you why I had so much trouble making this decision. I really hate the idea that I'm going to sit here and tell somebody else what they can't do with their property. So the idea to me is that the proposal isn't reasonable, what they were proposing, because it really is too large for the area. That and the drainage concerns. So I understand that we've had some testimony. Again, no disrespect to Mr. Mueller, but I certainly don't put all my faith in government regulations and what government officials tell us. That certainly fails on lots of occasions. And the fact remains that we have huge flooding issues downstream from this property. And this is this big complex that they're going to stick on this site. He's got real concerns for me for what it's going to do to the downstream flooding from this area. So I hope that the engineers are going to get it right and that we're not going to see this exacerbate the flooding. I hope I'm wrong and my concerns aren't valid, but I am particularly concerned about that. I don't think, on a maybe a final note, I am resentful of the idea, and it's been tossed around a lot, that we should approve this because of fear-mongering of what else we might get here. So it's not right for anyone to vote because of what might else be here. That's just not a way that you should conduct yourself in making any kind of a decision that you make. And I understand that I don't back up to the property, so maybe I'd feel differently if I were all of you. I don't know. You're right, I don't know. But what I do know is that that's been held over our heads as a way to get us to approve a project that somebody else wants. And I don't know if that's realistic or not as a concern. It's not affordable housing. It might never have been affordable housing or Mount Laurel housing. And yet that threat has really been tossed around by the applicant's side to really try to force us to give them a yes vote on this application. And I don't appreciate that kind of, to me, a strong arm tactic to try to get my vote to fall in a particular area by making those threats. I do feel that this project is better suited in the area that it's zoned for. These are some things that have come up from other people, so I know it's getting late. I don't want to keep belaboring some of these points, but the 34 and Route 35 overlay zones very specifically do include areas where this was planned, and this area was not. Again, the dementia patients, the people of special needs have a right to live anywhere in the municipality that they want to live, but they don't have a right to build a massive complex anywhere they want to build it. So the complexes of a very large size are better suited in areas that are better accommodating to them. In my opinion, 34 and 35 would be better suited. There are tracts of land that are available to have been purchased, to have been used for those uses. And 34 is actually really rural in character in many areas, and where it is on Red Hill Road there could really be approximated and duplicated on those areas of 34. So I think that covers, I guess just my last point that I didn't make is about the need. And that comes in really to the SECA test and to the balancing test. And the fact is that we now have 7 assisted living memory care related facilities in Holmdel. And I understand that the applicant has a certificate of need from the state of New Jersey that says we have a need for these facilities. But there does become a limit reasonably on how many of these facilities Holmdel Township has to be home to, and where the applicant may be better off putting it in another municipality. So we have 7, and we have reasonably accommodated this community with the 7 facilities that we've approved. So the issue is that we're not required to have an unlimited number of assisted living facilities in our municipality, and I think that 7 was the number where we should have drawn the line. I do agree that it is an inherently beneficial use, and that a dementia center is inherently beneficial, but we can say we met our burden with that respect with the 7 other facilities. So I think that covers what I have to say.
Thank you, Valerie. Irfan?
Thank you. Irfan Latif, and I've been in the town for last 22 years, moved in 2000, and a little bit as a professional. I also work in strategic planning and long-term objectives, though not in town planning, but engineering planning and technology. So as such, I have great regard for long-term plans. And having said that, after listening to the testimonies of the applicant witnesses, experts, and the objectors' witnesses, and weighing the inherent benefits and the impacts of the detrimental impacts, following are some of my observations. In terms of the inherently beneficial aspect, in fact, when I first saw the video of the dementia center concept, I was really wowed by its novelty and how it kind of really, in terms of what Joel Winter said, provides the dignity and empowerment to the people. So dementia center, like any other health condition, is very important cause, and I do believe that it needs to be addressed by the society, and UMC has obtained the certificate of need, and it's I fully appreciate the concept that it is required. However, it is a niche area, and if you see, it is applicable to people who are 65 and above, and then you further go down to assisted living people, and then you're further down to people who have dementia. So I think it has, it is the inherent beneficial aspect is limited in scope, or I would call it marginal at best. Having said that, looking at the other aspects now, the detrimental aspects of it, the biggest one, even though you have, it has been addressed here, is the comments by the EMC squad chief, where he clearly said that given the resources they have and the calls, it is not sustainable. But however, the testimony by Dr. Winters, when she gave, said they have experienced 38 falls in that particular month, and on average have 10 to 15 calls per month. I know Mr. Brown just pointed out 3 calls per month in your objection, but I am inclined to go by her real world experience rather than what we are proposing based on statistics. But that's but maybe the reality is somewhere in between, but bottom line I believe is there might be impact on the EMC squad, and that impact I think directly affects the ability of the squad to service rest of the residents and citizens of Holmdel. The next point is the environmental impact, and I will not go into the details that the CLUC provided, but I think as pointed out by Ralph here, I think the coverage is 22%, and even though mitigated by various factors, as you just said, the stormwater runoff is now reduced to 60%, even though the requirement is 50. But I think that assumes certain percentage of rainfall. The moment those numbers exceed, that is out of the way, and then it goes back to the concerns of flooding downstream near Parma Avenue and others. So again, I agree it has been mitigated, but I don't think that is a number set in stone. Anytime there is very heavy rainfall exceeding the average limits, we would experience some kind of flooding. And thirdly, the financial impact, as I call it, I personally believe that it is the cost of living there is high, and the economy is ready to go into recession as per all indications, and we don't know how it is going to turn out. But my bigger concern is not the financial sustainability of the organization itself, but just in case, if it doesn't sustain, then we are saddled with a property that cannot be possibly used in any other suitable fashion, as I don't understand or cannot conceive or perceive. So that is one of my concerns also. And finally, the most important concern is the change in the character of the neighborhood. The master plan has specifically designed this zone with the goals and objective, as I outlist here, given in the master plan, is to protect and manage the Holmdel's resources and protect the unique character of Holmdel and preserve the high quality of life. So I don't think by putting those large facility there, we can mitigate this impact, that it alters the character of the township. So finally, I think it is important to adhere to the master plan, because the Township Planning Board has spent hundreds of hours reviewing, updating the 2020 master plan, and giving the proposed facilities modeled after the Amsterdam facility, and it was highlighted, it was not to my attention, but highlighted by the objectors' lawyers, that it is built on 5 acres and it is built in dense urban facility. So I don't see no reason we can provide this. And Dr. Joel Winters pointed out that it is not the surroundings but the care that matters for the residents of that facility. So I think if you can if you can, in fact, relocate into an overlay zone on 35 and provide the same care and respect the master plan, I would urge the UMC to reconsider its size, location, and maybe put it in an overlay zone where the master plan is respected, the impact is minimized, and we have a facility in Holmdel at the same time. So in conclusion, I do not think the inherently beneficial aspects are tied to the exact location and do not outweigh the detrimental impacts on the township. So I am inclined to vote as no on this, even though it might not matter at this point. Thank you.
Well, thank you all for your comments. Marty, do you have enough to put into a resolution that's not over 100 pages?
Can't guarantee that, but I don't know.
Good.
Okay. We have to make.
Yeah,
When let's one of the people make the motion.
Yes, yes.
I'll move that we approve the application with the variances as requested and meeting all the conditions as discussed, and you will prepare a draft resolution which will come back to the board and to the attorneys for their review to make sure we got all the conditions. One thing that got mentioned today in terms of conditions, I'm not sure how permanent we can make certain conditions. You know, there's normally with regard to landscaping, like a 2-year bonding or something like that, but can you put in a condition that they have to maintain something like this for forever?
I think the agreement was to put it in the landscape easement, right in the easement itself, which will run with the land. So, yeah, this is not a bonded landscape.
Right, okay, but the thing is, there's parts of the landscaping closer to the building are not in the easement.
That's right.
The easement is the buffer toward the back, so there's still the desire that they maintain the attractiveness of the facility. That's in their own interest as well.
Well, we can't.
I don't think we
go back
can
and
do.
renegotiate
Yeah.
things. We'll
Yeah.
check the record, but minimally the landscape back area, if the foundations plantings were still to be worked out with the board professionals, that's one of the conditions. And that's
The
typically.
rain gardens too.
And the rain gardens, that's typical, but we don't have that in perpetuity in any application as far as a.
Correct.
Case.
Yeah, I don't know if there's anything beyond just the typical bonding
Right.
that we could do.
Right.
But, you know, the conditions, everything that's conditioned in the resolution continues to apply.
Correct.
Even after the plans are signed. So.
Okay, with that that's the motion?
Yes.
Is there a second?
I'll second the motion.
Any further discussion on the motion? Roll call, please.
Ms. Dabra?
No.
Mr. Luciani?
Yes.
Ms. Campus?
Yes.
Dr. Lateef?
No.
Mr. Gergel?
So I'm going to repeat it again. Yes, to approve the application with the mitigating conditions required by the board.
Dr. Blumenthal?
Yes.
And Ms. Perez?
Yes.
The motion passes. Just for everyone's, as a use variance, it's not simply a majority of the board, but that required 5 positive votes out of the 7. The result did get 5, so the motion passes. I want to thank the applicant for all the time they've spent in educating us over these many months. Good luck. I hope everything goes as you hope, and we have a wonderful facility in a finite period of time.
Thank you.
Right?
Yes.
Oh, absolutely. So, are we
Again, I
finished?
thank everybody on the board for a year's listening to us, and we much appreciate it.
One thing added, I don't know if we got it as a condition, was in one of the summary pages, that the enclave name will go away.
Oh, yes.
You have that because there is another development in Holmdel with that name, and the new name will be Avondel, Avandell.
Yeah, we're still waiting for federal confirmation of that, but yes, that's what we indicated, and certainly That's what we
Just
should-
want to make
It would
everybody,
it would
everybody's
definitely be
aware of
done.
that.
We hope it's on the bill.
Yeah. Okay, so thank you all. That's the end of a long process. And we'll take a 5-minute break before we go into three other items. Well, Loretta, I guess I won the bet. What?
I said that I repeat tomorrow with all the conditions of.
Can we add chicken salad?
I missed
Okay.
Good evening, everyone.
Good evening, everyone.
Yeah, okay.
Let's see. Moving, first of all, item 2, Francine.
Bina and Arthur Lazabinik, Block 30.01, Lot 7 in the R40A zone, zoning board variance number 464. Applicant seeks variance relief for lot coverage of 30.8%, where 25% is permitted for installation of an in-ground pool. Relief also needed for pre-existing mother-daughter.
This turns out to be far more complicated than the statement here. The mother-daughter means there's essentially an apartment in the house, and it's considered a separate unit, which is not permitted in any zone in Holmdel. There were missing, it was built that way by a prior owner who isn't around here anymore, who applied for permits and then didn't build what they got the permit for. And it's complicated. The Lazapniks, I'm not sure quite how to pronounce that name, had retained an attorney just recently. And there's a request from that attorney to carry this without further notice.
Correct.
Although, do they have to renotice because of the added variances?
No, the notice is still adequate. They did notice for approval of the mother-daughter. And Kate and I spoke about it, and I spoke with the attorney about it, who was just retained today. So we think we kind of all came to the conclusion it's probably best to adjourn it and give her time to absorb all the documents that were just, discovered, circulated this morning. And so the applicant's attorney agreed. And so they've agreed to carry this. We've all agreed to carry it without further notice. We did accept jurisdiction last time, so that's not an issue. But we have to carry it without further notice to the next available date. The applicant can come, but the applicant's counsel is the December 21st meeting, the last meeting of December. He's busy, all those other meetings we have, the other 3. So he's asked that we carry it to that last meeting in December. I believe it's the 21st.
That's the benefit of the board, because so much new information was coming out and it was not fully vetted or not. Right, so that Kate hadn't seen it, Bob hadn't seen it.
I had seen it, but we have the paper trail from the community development office, and I'm probably going to write a brief report up for this one, just so now we have the time.
And the use.
Because, that's generally, the standard. Obviously, I don't write reports for most of the backyard applications. Unfortunately, this is a more complicated situation that could potentially require a D1 variance, so that's what we, but that's, I think it just makes it easier for both the applicant and.
So the conclusion was let the professionals and the attorneys meet and talk and get all the facts and then come to the board with it then.
We're not going to meet with him, but he's going to get all this stuff and look. And he can talk to our
Yeah.
professionals, obviously. Yeah.
Right.
Could I just ask a question?
Yep.
You mentioned there's an ordinance in Holmdel against mother-daughter?
It's not specifically permitted in any zone.
So what would somebody have to do?
Well,
Come to the zoning board.
Well, no,
And
hold on.
it's a misnomer. Let me-
Let's not,
It's
let's not
the
testify about what.
access door, separate access door, and I believe, and with separate kitchen, which makes
And
it
bathroom.
deemed to be almost like a secondary house use apartment, whatever you want to call it. So you could have a mother-daughter in your house, right? Separate wing,
Right.
no separate entranceway, no separate kitchen, and that's approved. I mean,
Right.
and that's what that's apparently what was applied for and approved. And I guess with the addition of the door and/or the kitchen, it became that was not permitted.
So just a question I'm trying to learn here. So a lot of basements, and we have these large walkout basements that have doors going into them, and there's a secondary kitchen downstairs in the basement. Is that not, how does that apply to a mother-daughter? If there's bedrooms downstairs in the basement as well?
So mostly, they don't let you, use that as separate living space, and they'll make you put a deed restriction on your deed to restrict what you can do with that space. Like, you could always have your parents live with you,
Yeah.
but there's no law against that.
But you can't call it a mother-daughter.
You could call it a mother-daughter if you want to. I mean, you could call it anything. A mother-daughter is not a legal designation. It doesn't have a separate legal approval, right? It doesn't. So it's a descriptive term that people use to describe a separate living area for another part of your, is your family, right? That's really what the term's used for in real estate. It's not a legal term of art.
So what, I guess then what is the issue? I know we're gonna talk about it
Yeah,
next
Well,
week.
again, it's not-
and I would also just note that in addition to what Valerie said, which all of which is correct, is that the construction and building departments have they have other standards of review that determine whether or not something constitutes like a second unit. You know, it has to do with egress, it has to do with, you know, shared access, things like that. And that's how this came to, you know, this attention, where upon, review of the new plans, they realized that something had kind of been erroneously sort of approved, maybe someone prior, something happened at some point, and so that's what we're still kind of working out. But, it's not, it is something that, considered on a basis. A lot of people have two kitchens, My mother grew up with two kitchens. Half people, they cook the sauce in the one in the basement, that one, no one was living down there. But there are, so, it's not a, it's not a constant, but it's not defined in the ordinance. So that's how we're going to get this level of protection.
But so leave with the last note. This current applicant did not do any of this, right?
Yes.
So the question is, what's the best way to let her move forward with both that and what she's coming in for originally was for a pool. She needs lot coverage for her pool. So she's one of those houses that's built to the max. Actually, with this,
No, it's over.
A little bit over. Right.
One of the 04 complaints was that it was over and they need to reduce the coverage to what's allowed. And now it stayed over and went over further, and now they want more.
We don't have the facts, and we're on this, whatever we're talking about here is just generic. It's not,
Right.
We'll
Okay.
listen to the testimony when the hearing actually starts to formulate.
Okay, moving on. Item 3.
2 Yellowbrook, Anthony Pesci, Block 25.03, Lot 16, in the R40A zone, zoning board variance number 467. Applicant seeks to reaffirm and/or waiver statutory timeframe for a previously approved setback variance for a pool pavilion. Applicant was unable to secure building permits within the 1-year timeframe due to outside agency delays regarding a fence within an open space easement. The fence has since been relocated onto the property line.
Welcome, Anthony.
Good job. Little different from down here.
Better, right?
Should we all get down saying conflict of interest?
That outside agency includes Holmdel Township Committee.
So Anthony came in for a variance. The issue, he was granted the variance for the pavilion, but because his fence was in the open space easement, he had to go to get governing body approval. And that took some time going back and forth, and his extension for is 1 year. He gets 1 year with the variance, with both permits. He was out of that 1-year period for about 3 weeks. So we wrote this, which you will have. I'm going to reaffirm the approval. The fence is now on the property line. I gave you all a copy of it. And we're just going to reaffirm this variance approval for the pavilion.
So I would say there's no circumstance under which we would not grant someone that was granted a variance a extension, or at least based on good cause. So I don't know if we have to have a discussion. I would make a motion to grant the application.
I would second that.
Marty, do you have any other comments on this?
No, that's Loretta accurately
Question,
stated.
do I call for a motion and then to memorialize it in the same vote?
We can, because we actually have, you typed up essentially the cover page, which is a reaffirmation.
Do that at the same time or second?
Second, we'll do a second.
So we'll do first.
Okay, so Ms. Avron,
Yes.
Dr. Blumenthal,
Yes.
Mr. Burkle,
Yes.
Ms. Mathis?
Yes.
Dr. Latif,
Yes.
Mr. Luciani,
Yes.
and Ms. Perez.
Yes.
Okay, now we're gonna do the memorialization.
Can you do a motion for that?
Motion, yeah.
Okay,
To
I
approve.
make a motion that we approve the resolution that's been drafted, reaffirming the prior resolution of the zoning board. on December 2nd, 2020.
Is
I'll-
that this?
I'll second that motion.
Oh, I didn't see that.
So just for a quick record, Loretta had just, she ran it by me, but she prepared this just to, as a cover page that is gonna attach the old resolution to this instead of doing a whole new resolution and keep it all reasonable.
Okay, reaffirmation of prior resolution.
That's right.
So, anyone else want to see it?
We don't have it. We don't have it.
We have it?
Yep, somewhere.
I didn't.
Thank you, Loretta.
It's in your stack.
And, so we have a motion and a second, Savran?
I seconded that. I second the motion. Yes. What was that? And then I'm seconding it.
I'm doing the memorialization roll call. Ms. Savran?
Yes.
Dr. Blumenthal?
Yes.
Mr. Berkel?
Yes.
Ms. Campus? Yes. Dr. Latif?
Yes.
Mr. Luciani?
Yes.
Ms. Perez?
Yes.
I want to thank you all for making this the most painless part of this whole project. Thank you.
Don't expect that treatment.
Good to see you. No, go Yankees.
Anthony, is that your mural on the ceiling in 2 Beers Street, 2 South Beers?
Yeah.
Yeah, my good friend Marty out of my bought the house from you.
No kidding.
Yeah, there's an incredible mural on that room on the right there.
I
Yeah.
loved it so much. I did it in my new home, But the person that did that really did a great job. Good luck to you all. Thank you. Thank you very much. Okay, great. Thanks.
Okay, item 4.
Yours is not gonna be quick, don't get it.
Not as friendly now, is that right?
Francine, item 4?
Item 4, 4 Windswept Road, Lorianne and Frank Marciano, Block 50.22, Lot 14, in the R40A zone. Zoning Board variance number 465. Applicant seeks variance relief from rear yard line of 15 feet, where 25 feet is required for pavers around in-ground swimming pool.
Okay, well, wait,
I have a couple of things.
Just a clarification.
just a sec.
I want to say that the name is common and I have no relationship to the applicant, but I don't know if you remember me, but because of the name, I remember you. So I represented the people who sold their house to you.
The Palillas?
Yes.
Oh, wow.
So I have discussed it with our attorney, and we actually obviously never met because we don't come to sellers, don't come to closings anymore. But I represented the people who sold to you. I don't view that as a conflict. I don't know you. We've never even spoken, but we like to be transparent and put things on the record. So I'm putting it on the record. Do you have any objection if I sit on your application?
No.
Again, I don't see it as any conflict of interest, but if you felt otherwise, then I would recuse myself, so.
No, we have no issues.
Okay. Loretta, do we have, is the escrow and notice and all of that's in order?
And we did accept notices last time.
Yes, we accept them for.
Oh, yeah, this was carried from the previous.
So how many people will be testifying tonight? Just the 2 of you, or?
Yes.
So we just swear you in, just so we're sworn in, and I guess, Bob and Kate, if you're gonna say anything, wants to swear you in now, just raise your right hand, you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
I do.
So for the record, the applicants, as well as our board professionals, have been sworn in. So. You can.
Go ahead, you want to present?
Good evening.
Your case, so you have, you need to make your case, it doesn't need to take a year, as in the previous application. So just go ahead and explain what it is why you're here, what you're trying to do.
Do you want me to?
Good evening, Chairman and honorable board members. So my wife, Lorianne, and I, we purchased this home, and we are installing a pool at the rear yard. And the pool is 25 feet, according to the zoning ordinance. And the lot coverage is way under at 19.7%. The issue at hand is that the pavers that surround the pool happen to be within that 25-foot setback. The reason we, together, we plotted different scenarios where if we had placed it closer to the home, it would, as you can see, there's existing porch pavers. The pavers would then be so close, and there's walls here that my wife and I would not be able to see the children as much if we were sitting on the patio or if we were at the window in the kitchen. So for that reason, we placed it in the location that you see it now. So the pavers are at grade, they're not raised. We are providing required fencing. Beyond at the property line, we are also looking to provide and install hydrangeas, beautify around the pool and the pavers, some boxwoods. Anything else you want to add?
No, I mean, the one thing I want to add, which is, I guess, unrelated to the pool, although it is one of the reasons why we moved to Holmdel, is to give our kids a better life and a yard and a beautiful community, is that we have 3 children who are very excited about the pool, and as my husband said, we when we originally went and put the request in for the pool and were denied and had to come in front of all of you, we were like, wait a minute, well, if they're telling us this, maybe we should do like how they want us to do it. And with the existing patio that is actually beautiful, that I would not want to rip up, and this is already like an enormous expense doing this, we plotted it, and like he said, there's this like raised, I guess raised patio portion, and when you're sitting down, you can't see like the kids where the pool would be if we did it, I guess, a
Right.
few feet this way. It's a large yard, there's no one behind us.
That's one other thing I want to mention, that
So that's why we feel that we are placing it at where it should aesthetically be, like for safety reasons, and also just because that's kind of like where we feel
Right.
it should be in
What-
the yard.
What is on the property behind you?
it's township land. On one side, it's 600 feet to the rail line. On the other side, it's 800 feet to the rail line, New Jersey Rail. So there's nothing behind us.
Is that a township? Or?
It's a 10-acre township-owned parcel.
It's an isolated parcel?
It technically, it connects to Redberry Road, which is the cul-de-sac, slightly to the west of the applicant's property, and it also connects to Wind Hill Way, which is slightly to the south.
But it doesn't touch the Palma.
It does touch the Palma, yes.
It does.
Yes.
Yeah, because that's, concern is often is what's the impact on the neighbors?
Oh, I know, you're down the street from me. Yeah, you're good. I know where you're. There's no one behind them. The Holmdel Planning was yours, incentive.
Yeah, it's a property that goes along, there's a couple of them in this area that goes along the rear of this development. I'm not sure if it was dedicated to the township at the time of this subdivision or how it got to be there, but it is included there.
Yeah, because then Dearborn Farms is like right straight.
You know the funny thing about zoning?
Yeah.
So, in my neighborhood, which is all that far away.
Oh, it's
from
here, and
I
it's
can
right
have a
next to
pool
the
10
Palma.
feet off my property line, because my lot is small. But because you have more property, you're punished for that. And you're 15 feet, right?
Well, the pool is 25 feet away.
And the pavers are 15. Well,
15 feet
Your
away.
pool is fine, it's your pavers.
Right. Which is a removable, it's not a permanent structure like the pool, the actual pool itself.
So the fact is if you were in my neighborhood, down the road from you.
So Dearborn is right there.
Oh,
Dearborn
okay,
first.
from
So-
Dearborn.
So they've
And my engineer was actually
empty land.
surprised to have
It's all
found
empty
this
land.
to be an issue because this had never come up.
there.
And he had designed plenty
So
of
over here.
pools around our
This is-
neighborhood in
this- They have a
Holmdel,
buffer
and this
here.
had never
There's
come
no
up.
house here.
Another
There's more house
Marlboro
there.
and
They have a
the
buffer.
township.
So they're bumping with nothing, it's just open land.
Dearborn and then,
Pure open land.
well, it's now shut.
What sometimes has to do with when properties are developed under the cluster. This property was probably developed under, if it was, for example, the R48 cluster. So the property is smaller, but certain setbacks do remain in place.
Well, this property's not small, For Holmdel, I mean, this is almost, this is over 3/4 of an acre.
Right, but R40A is typically an entire acre. So, yeah, so that's what I'm saying, cluster-wise. So, yeah, so it does get a little confusing there with.
So that lot behind is probably part of the cluster.
That's my assumption.
Yeah,
It was
okay.
developed all in, that was the preserved land.
I mean, I don't know if anyone wants any discussion. I'm fine with this. I'm ready to make a motion for the variance. So it's such a minimal variance for pavers only.
And there's no one behind them.
There's nobody
Yeah, I
behind
think
them.
That's
And
key.
it's still 15 feet off the property line.
Yeah.
It's not right on top of the property line. Again, I'll note that Holmdel Township has a wooden shed 2.3 feet off the property line in violation of its own ordinances. Anyone object if I make a motion? No. All good? I make a motion that we approve the variance request to allow the installation of the pavers as depicted on the applicant's survey. Again, this is for pavers only, right? That's all the variance
Yes.
is specific to allowing you to put the pavers in this location.
I'll,
See, the pool is 20
It's
feet.
already legal.
The pool is 25 feet. When pools are measured, I believe, that the Lonnie measures it in accordance with the ordinance, is that the paver is where the setback is taken from.
Okay.
So it's just the variances for the pavers.
So we have a motion, was there a second?
I'll second.
Francine, a second? Okay, roll call?
Ms. Aaron?
Yes.
Dr. Blumenthal?
Yes.
Mr. Burkle?
Yes, to approve.
Ms. Campus?
Yes.
Dr. Latif?
yes.
Mr. Luciani?
Yes.
Ms. Perez?
Yes.
Thank you.
Okay.
Thank you all for your time. Thank you. Thank you so
And,
much.
let's see.
My kids, thank you.
I hope they enjoy
They're
it.
watching
Okay.
now. They're probably screaming. They're watching live stream.
Love this live.
Yes.
Kate, do you have anything else for tonight?
Pool is going in.
Yeah,
Bob?
they all summer, all year, but that's not happening.
Do
We
you have
don't
anything
believe
else
you.
for tonight?
Trick on them?
You got it, boys.
Thank you,
Okay,
everyone.
good night. You have anything else for tonight? Loretta, you have anything else for tonight?
I just want to say November 9th, we have Holmdel self-storage. I gave you all.
We got new plans. They are seriously revised.
Right, and I just want to tell you, I have asked them for small copies instead of the large ones as well. So I'm
Okay.
getting those in,
Okay,
all right?
And
So,
we'll be issuing a new report prior to that meeting.
okay, yeah, good. If there's no further, anyone have any other business? If not, is there a motion to adjourn?
Oh, yes.
Second? All in favor?
Yes.
Aye.
Opposed?
Ralph's a Yankee fan.
I was gonna say, how's the Yankees? Well, how the Yankees doing? Okay.
Let me
Oh, yeah, you
show
bet.
you something else. Just ask
I'll be-
you.